This is for constitutional law on Tuesday, April 28th, 2020. And what we'll be doing in class is finishing up with the incorporation doctrine. And in particular, the one case that we haven't covered in class, which is important, is Lochner V New York. And I'll just say something about that now. We'll talk a little bit about that in class. Why is Lochner so important? Because it does not necessarily, as I mentioned in my notes, it doesn't have the odoriferous reputation that, say, Dred Scott has, or Korematsu v. U.S., but it's not a treasured or cherished precedent in the court. Nevertheless, I would argue it's been very influential, and as I suggested, you will see it reappear in Rehnquist's dissent in Roe v. Wade. So why is this so important? Lochner seems to concretize and express a concept that grew on the court during the 1800s and is most evident here. And as I talked about in class, that concept is substantive due process. And as I mentioned in class, that's an oxymoron. It's like Microsoft Works or a working vacation. It contains a self-contradiction. Why? Because due process is an intrinsically procedural test. Due means requisite or enough. Process means procedure. Technically, what the Due Process Clause requires as a standard in criminal prosecutions, and that is its core application, is has the individual received sufficient procedure to guarantee a just a trial and a proper outcome. Now, of course, we know that just because you follow proper procedure, that doesn't necessarily mean you'll come to the right outcome. But nevertheless, the suggestion is without enough procedure, the process is flawed. For instance, in Powell v. Alabama, it's clear that at least to Sutherland, rather than to Roberts, that these 8 individuals did not receive a trial that was sufficiently procedural to produce justice. So, in the 1900s, or in the 1800s, and especially embodied in Lochner, the idea seems to be that the Due Process Clause, it's not about procedure, it's about substance. But what's the substance? What is the substantive requirement? And as you'll see, the debate between Peckham and Holmes is Peckham seems to suggest that the problem with the law requiring, putting limits on the hours of bakers, etc., was that there wasn't a good reason for it. So the test of substantive due process in this understanding is the test is that the law has to be reasonable, that it has to have a good reason. Now, Holmes's response to this is that you've turned the judge into a legislator. In other words, if you were sitting in the legislature, you wouldn't have voted for this law. You didn't think there was a good reason for it, or that it was unnecessary. And in some ways, that's the primary criticism. Now, how did the 14th Amendment's Due Process Clause come into this? Because what Peckham seems to be suggesting in Lochner is okay, since the Due Process Clause requires that states pass reasonable legislation, that if the legislation isn't unreasonable, then it violates the Constitution. So, again, Holmes's criticism is you've actually turned a substantive weighing of the policy questions of a law into a issue of constitutional interpretation. But what's the answer to whether or not it's constitutional? It's whether the judge agrees with the necessity or the rationality of the law. And as we'll see, that becomes a controversy. So why is that within the incorporation cases? Because in some ways, it's not just whether the Bill of Rights was applied to the states, but rather what clause. And there are 3 clauses: the Privileges and Immunities Clause, the Due Process Clause, and the Equal Protection Clause. The Equal Protection Clause has its own independency and existence. But you could say that only when due process was transformed as a concept could you squeeze the rest of the Bill of Rights into it. And that seems to be the way the incorporation doctrine was formulated. So we'll finish that with that, and then we'll what we're turning to tomorrow is the Bill of Rights. Since, of course, the results of the incorporation doctrine meant that by and large, the reason the Bill of Rights became so active as the primary source of constitutional law is because the court applied it to the states, whereas that's where most of the legislation that governs American life is. So to be sure, some of the cases we'll be discussing are on the national level, like Schenck v. U.S., but on the whole, the vast bulk of Supreme Court 14th Amendment cases or Bill of Rights cases are applied to the states of the 14th Amendment and the incorporation doctrine. So what I want to do with these comments is just lay out a broad introduction to the Bill of Rights. And what I want to do is discuss the interpretive strategies that the court has developed. Now, let me just say, by way of analogy, what's the difference between the incorporation doctrine, which has been powerful and influential in terms of how the court operates and what it pays attention to constitutionally? What's the difference between the incorporation doctrine and the strategic approaches that I'll lay out? Basically, three of them, you'll see in just a minute. How the judges view their role in interpreting the Bill of Rights and applying it to issues of policy and legislation. The analogy is to the Reformation and the Renaissance. Now, the Reformation is a historical period that began roughly, actually pretty precisely, in 1517, when Luther attacked the 95 Theses regarding church abuses on the Cathedral door at Wittenberg. And then in 1536, John Calvin published the Institutes of the Christian Religion. So there was a historical period called the Reformation. There was also a historical period called the Renaissance, which began roughly in late 1300, early 1400 in Italy, and changed the way culture and language and history and art and science, kind of a rebirth of ancient learning, the Renaissance, the rebirth. And as a cultural movement, that kind of began in Italy in the 1400s and moved northwards. We talk about the Southern European Enlightenment, the Italian Enlightenment, the Northern European Enlightenment, the Scottish Enlightenment, which finished about the 1700s or almost the 1800s. The difference is this. The people who actually lived in the time of the Reformation called their movement the Reformation. They self-consciously formulated its doctrines, and they called themselves reformers. The people who lived in the period of the Renaissance did not think of themselves in a Renaissance per se, or call themselves that historical period the Renaissance. That was primarily floated by a historian in the 1800s, Jacob Burckhardt, who coined the term Renaissance. Now, we today look back on that period and call it the Renaissance, but basically that was a way of periodicizing or describing history by a scholar in subsequent ages. So again, they both refer to historical periods and are useful analytically for describing what was going on in European life. One difference, though, is that one was self-conscious and formulated by the individuals participating in it. The other one was a way of classifying things retroprojected onto it. The three strategies for interpreting the Bill of Rights that we'll talk about have more or less been developed by commentators and scholars looking at the court and classifying these different approaches. So what I'll do is roughly go through the first 8 Bill of Rights and talk about the issues raised in each amendment. What tends to be the specific issue that the court is raising, or issues with specific to what rights. But then, as you'll see, just as we saw with many other issues, there is this other issue, this other question of how the court should be doing its work. How should it be using judicial review? And you'll see there are different answers to that, what kind of strategies and the different philosophies on the court. So there are these two issues, the content of the right and how to approach it and apply it to American life, but then also what's the proper role of the court, its attitude, and its respect towards the authorities that it is holding accountable by its constitutional standards. So let's go through the amendments. The First Amendment, there are 5 rights in the First Amendment. If you count all the rights in the first 8 amendments, you could say there are about 23 to 24 rights, depending on how you divide them up. So there are 5 rights in the First Amendment. With respect to the amendments, the First Amendment, which says Congress shall make no law, which supports, by the way, Chief Justice Marshall's opinion in Barron that these amendments were meant to limit the national government because, after all, it says Congress shall make no law. But, of course, as we saw, the 14th Amendment in the incorporation doctrine changed all that. So speech and press tend to get clumped together and in fact, tend to be expressed as the right of expression today, whether or not the right to free speech, the right to a free press, is the same thing as the right to express oneself is a different thing. And as we'll see, that gets into shady issues like speech versus action. When action has expressive content, is it protected? And I would say that the court has generally said yes to those, as we'll see, and has not particularly formulated a clear distinction between what should be permitted in the name of speech and or press and or this larger thing called expression. As you're going to see, that's a little more wifty. But at any rate, so with respect to speech and press, these tend to be the questions. May the government restrict these rights? And under what conditions? War? Is emergency? Peace? These are different constitutional conditions, sort of like we saw in Korematsu, and as we'll see in Schenck, by the way. And oftentimes things like national security come into that. There the question tends to be prior restraint. Can the government beforehand put a limit on what kind of speech is permissible and what kind of press? Now, we know in some ways the answer to that is yes, because we allow, for instance, government to classify information. Classified information is information that, if it's disseminated, is punishable by law. But again, generally speaking, you'll see that when you come to different strategies, that the court is generally hostile to the idea that government may limit speech. But if it is to limit speech, especially in terms of military necessity, national emergency, etc., and with respect to what issues? As I already mentioned, national security, but the other kinds of issues that have come up in speech and press are libel. Now, British common law has a very robust libel and slander tradition, where, generally speaking, to prove somebody guilty of libel or slander, you simply have to prove that it's false. As we're going to see, the American attitude, because of the First Amendment, is to raise a higher bar. And as we'll see, proving, especially with respect, say, to public figures, proving that something is false is often not sufficient to establish libel, but rather, you've all heard the phrase absence of malice, but to show that the libelous material actually was malicious in intent. So we still have libel law in the United States, although you'll see some justices, and you'll see the same justice who was a total incorporationist, Justice Black, was also, as you're going to see, an absolutist when it comes to these rights. More about that later. Obscenity. The court has never fully said that you can say and do anything with respect to decency, and probably the phrase that came from the court's 60s jurisprudence on obscenity, no redeeming social value. The court got itself into the business of screening pornography, and at one point Justice Stewart was quoted as saying, with respect to pornography, I can't say what it is, but I know it when I see it, because the court would have to resort to its chambers and then watch pornographic films to see if it violated. So it wasn't particularly successful in, I think, erecting a clear standard, but you'd have to say that generally speaking, although we've gone pretty far with the First Amendment and expressive rights, when it comes to obscenity, it's not absolute. Fighting words. These are very controversial, like when a pastor might excite somebody to go out and do something. Ku Klux Klan leaders, incendiary speech. Generally speaking, our tradition is to not put responsibility on a speaker for exciting someone to action, but there are exceptions to that too. And of course, the difficulty, as we saw in Gitlow and to some degree Schenck, advocacy. We've talked about this in class. You can't, for instance, talk with other people or write to them or email to them and to plan a bank robbery. That's called conspiracy. But does material that advocates the violent overthrow of the Constitution and U.S. government, is that prohibitable? And the court has been narrow, wide on that, and depending on the effort. You could say that during the 40s and 50s, perhaps during the Red Scare, the court was more latitudinary in allowing government to outlaw certain kinds of speech and association. By the time of the Warren Court in the late 50s and 60s, it was more latitudinarian in terms of allowing people free expression. With respect to the two clauses that govern religion, the issues tend to be, may the government prohibit certain religious practices? And the courts generally said there are certain practices the government can prohibit, like, for instance, snake handling or poison drinking, or etc. May the government permit, in the name of religious activities, activities that would otherwise be illegal? This is a little sensitive, and so, for instance, and here's why. And the answer to the court's question is, generally speaking, no. And by that came up with the coronavirus, where some governors, for instance, were prohibiting any public gatherings of more than 10, including church services. But doesn't the First Amendment protect people in their worship? But the answer is, the First Amendment protects religious belief, certainly, but doesn't provide an excuse to violate otherwise valid civil laws. Otherwise, the observance of national laws would be dependent upon your religious tradition. Now, of course, there are conscientious objectors, but you have to remember there's no constitutional right to conscientious objection. That is a gratuity granted by Congress or the legislature. So, but nevertheless, that's a question. May or must the government protect the religious rights of individuals or groups that may conflict with the rights of other groups? We'll read this in this very recent case, controversial case, the Masterpiece Bake Shop case, the one that occurred in Colorado. And still hot and controversial, and we'll take a look at that. With respect to the Establishment Clause, the questions tend to be, what constitutes establishment? By the way, the First Amendment went through several stages when it was being drafted. Madison's original draft said no national religion shall be established. But the reason that it ended up with this clunky language, Congress shall make no law respecting an establishment of religion, was about 6 of the states had established religions, official religions at that time. So on the one hand, they seem to want to make sure that Congress couldn't set up an official national church and at the same time not interfere with state-established religions. So as we're going to see, in the Everson case is one of the classic cases we'll see. The court tries to define what does the Establishment Clause prohibit and permit. So, and as we'll see, the court has in the 50s, 60s, and 70s has tightened up that standard. For instance, does the First Amendment or Establishment Clause prohibit any public prayer? Does it prohibit any public involvement with religious activities or institutions? We have a national Christmas tree lighting. We don't have a national menorah lighting. All the foreign services have military chaplains, which are employees of the U.S. government and are officers in the armed services. Our money says in God or tough. In France, the modern republicanism is purely secular. In America, the question of interpretation is does the First Amendment require us to be like France, or is it softer with respect to the line? And the court has formulated since Everson what's called a high wall theory. Now, that was Jefferson's term. It wasn't a constitutional term. I mean, people think the high wall of separation, or the separation of church and state, is in the Constitution. That's not a constitutional term. Non-establishment is. So, again, that's a controversy. And the court has kind of raised a high bar in the 50s and 60s, absolute neutrality, high wall of separation. But in the 70s and 80s has moved to a more accommodationist approach called accommodation. So, can any government support or assistance go to religion, or must the government remain absolutely neutral with respect to spending and support? We saw, by the way, in the Flast case that raised just this question. With the Second Amendment, and generally speaking, up until 2010, the court did not incorporate the Second Amendment as one of the fundamental rights. In the Heller case, which we'll read, it changed its mind, and now in this selective plus incorporation position of the court, it has moved in that direction. So what tend to be the questions? We'll see the complex structure of the Second Amendment. It has a main clause and an adjectival clause. And so one of the great disagreements on the court is what actually is the nature of the right in the First Amendment. Is it a personal right to bear weapons, or is it a state or public right to maintain a militia? And we'll see in Heller, the court lines up along those two questions. And of course, what are reasonable restrictions on that, right? Nobody would agree that you have a right to keep a small yield nuclear weapon in your basement. So the Third Amendment, no quartering of troops, has never been controversial, has never given rise to a Supreme Court case. Americans seem to have agreed on that one. The Fourth, Fifth, Sixth, and Seventh Amendment, more about that in a minute, and the Eighth Amendment, generally speaking, cover the whole range of criminal procedure. The Fourth Amendment, the arresting executive authorities when they come to pick you up or come to your house to arrest you or to look for evidence. The Fifth Amendment, the guarantee of due process and fair indictment and other procedural protections. The Sixth Amendment, the trial, the sixth, and by the way, there are, depending on how you count them, 1, 1.5, 2 rights in the Fourth Amendment. The right to be secure in your against unreasonable search and seizures. And then it also says, nor shall warrants issue except the probable cause. Does that mean you have a right to a warrant? No. You have a right to a warrant issued with probable cause. So you could say that's 2 rights or 1.5 rights. The Fifth Amendment has 5 rights. Indictment with grand jury in capital cases, due process, as we've already seen with Hurtado and other cases, non-self-incrimination, non-double jeopardy, and eminent domain and public compensation for taking private property. The Sixth Amendment, depending on how you count them, has 6 rights: speedy and public trial, impartial and local jury, confront your witnesses, process, counsel, and I'll have to look at it, but certainly 6, possibly depending how you use them. And the Seventh Amendment, the right of trial by jury in civil cases, because of that $20 amendment, it's never really given to a case, kind of faded out, and the Supreme Court has not incorporated that into the Bill of Rights. And then the Eighth Amendment is at the end of the criminal process, the punishment phase. No excessive bail, no excessive fines, and no cruel and unusual punishments. And we'll look at the Furman case, because of this amendment, the court invalidated the death penalty. So, and as for the non-textual or fundamental rights adumbrated in the Ninth Amendment, we'll see that's where the right of privacy has been formulated in Griswold, Roe, and in Lawrence. And that's how we'll finish the course. So what are the 3 strategic approaches? Again, these are not airtight, except I would say the last one is probably the most discernible one. Generally speaking, going back to Korematsu, where Black and Frankfurter, all the judges understood that the Constitution grants the national government the war power, and in other words, governing is one of the aims of the Constitution. Protecting rights against bad governance or excessive or tyrannical governance is another point. So clearly the Constitution has different values. So these different strategic approaches really have to do with how the judges weigh in the balance the demands of government and the demands of individual liberty or immunities. The first approach is called the balancing approach, and that has governed some judges like Frankfurter, Harlan, the second Harlan on the court, not the first Harlan, and in some ways has been a kind of a plurality position. The government doesn't assume that personal liberties are more fundamental or more important than governing, and the task of the judge is to look at each one in a case-by-case manner and decide which one has to win in the case, without a prejudice to either side, individual liberties or the demands of governance and public necessity. Probably the majority opinion, and I would say this is Holmes and Schenck, is the preferred freedoms approach. It's a balancing approach, but in this approach, you can see it's a difference of degree rather than kind. The balance should be tipped in favor of the individual rights. The argument is the reason those rights are enumerated in the Bill of Rights and added to the Constitution is the Constitution is trying to privilege or prefer those rights, preferred freedoms. So even though the judge has to take into account the necessities of governance, his constitutional preference should be guided by trying to find the maximum scope of these individual liberties, because they are enumerated. The preference of protecting and securing individual liberties should have preference over other governmental values. Not that those other governmental values aren't important, but the Constitution prefers the individual liberties in the Bill of Rights. That's probably the majority opinion on the court. Then there's the absolutist position. The Bill of Rights are absolutes. They are to be read literally as absolutes, but only those which are explicit and listed, no implied rights. The most interesting judge in this case who advocated this was Black. So Black, for instance, would have no obscenity laws, no libel laws. When he said Congress will make no law, he meant it. There can't be any laws restricting freedom of expression and speech. As for national security and classification, he could waver on that. But his argument was that because those are enumerated rights, they are therefore absolutes. And you'll see, both on the total incorporation position and on the absolutist position, as the court began to formulate non-enumerated rights under the Bill of Rights, Black became consistently alienated from the drift of the court, and you'll see this in Griswold. So tomorrow we'll look at these issues and we'll examine the First Amendment right of expression and press in Schenck and political speech in Citizens United.